Good evening. Good evening to one and all. Good evening to all the seniors, friends, and participants. I sincerely welcome one and all on behalf of my team Legal Speak webinars. I welcome Mr. Parthiban, advocate from Supreme Court, who is going to give today's presentation on the topic of admissibility of hearsay evidence, that is dying declaration. Mr. Parthiban completed his law degree and enrolled in the year 2009. Initially, he was associated with senior civil expert Mr. G. Ethirajulu in Madras High Court. Then he moved to Delhi and he continued his profession in Honorable Supreme Court. There he was associated with Mr. P.S. Narasimha, Senior Advocate, Additional Solicitor General of India. And he assisted so many cases along with him in the Supreme Court. Mr. Parthiban, in the meanwhile, cleared the exam for advocate on record in Honorable High Court in 2018. Presently, he is one of the panel advocate for conducting Central Government Standing Council as Central Government cases. He has got various knowledge and more experience. He is also in all sorts of cases in both civil and criminal in Supreme Court. Over to Mr. Parthiban to start his presentation. Thank you. Thank you for all participants.
Good evening, seniors and my dear brothers and sisters. I would like to thank my Gurunather, Mr. G. Ethirajulu, with whom I started my practice before the Honorable High Court of Madras. He is the one who encouraged me to shift my practice to New Delhi, and for that I'm always grateful for him. And he's more like a father figure to me. The topic which I've chosen today is admissibility of hearsay evidence. You must be wondering how can hearsay evidence would be admissible in evidence. But in the course of this lecture, I would try to prove my point that in what aspect a hearsay evidence would be admissible. I would like to start with some basics, fundamentals of Indian Evidence Act. I'm very sure that most of the lawyers would be aware of this basic fundamentals, but I know there are a lot of juniors are there in this lecture. So I would like to start with some basics. So if you take an Evidence Act, there is something called fact in issue and relevant facts. Fact in issue, that is a facts which needs to be proved, is called fact in issue. To make it easy and to understand, in a civil cases, issues are framed under Order 14, and similarly in criminal cases, charges framed under Section 211 are called fact in issues. So issues in a civil case and charges in a criminal case are called fact in issue. What is the relevant facts? Those facts which will be necessary to prove or to establish the fact in issue is called relevant fact. Chapter 2 of the Indian Evidence Act deals with the relevancy of facts. Section 5 states that what evidence may be given in facts in issue and relevant facts. The definition of Section 5 states that evidence may be given in any suit or proceedings of the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and of no others. Kindly mark the word no others, because if it is a relevant fact which is you wanted to produce before the court, you should either fit in any of the section, that is 6 to 55 under the Section 5, which talks about the relevancy of fact. If you cannot bring it under any of the section, then it is inadmissible. So to make it an easier way, if you want to bring in any evidence, that evidence should fit in with any of the section from 6 to 55 of the Indian Evidence Act. If it is not fitting in, then it cannot be admitted as an evidence. Except the relevant facts coming under the chapter, as I already told, no other facts can be let in as an evidence to prove the fact in issue. Under Section 60 of the Evidence Act, you must all be knowing that hearsay evidence is per se inadmissible. But there are certain exceptions to this rule. The first exception is that found in the Act itself is that Section 6, known as res gestae. Res gestae evidence is not relevant for today's topic. Maybe if I get a chance, I will explain it to you in the later lecture. Now, the next exception is section 32 and 33. Section 32 deals with the cases in which statement of relevant fact by a person who is dead or cannot be found, etc. Now, before going into the section 32, I would like to explain what are the consequences would arise if by relying upon the statement of person who is dead, who is unavailable. First consequences is that it is an exception to the rule of hearsay evidence. That is, a statement made by a person who is not available is an exception to the rule of hearsay evidence. Second point is that the opposite party has no opportunity to cross-examine the person whose statement is being relied upon because he or she is not available. The third consequence is that court and the party cannot see the demeanor of the witness. That's because the person who gave the statement is not available. Now, the two important aspects or rights which is lost by relying on the statement of the person who is not available are: first one is, as I already told you, they cannot be cross-examined. Second is that a court or a party cannot look into the demeanor of the person who made the statement. These two important aspects, these two important rights is virtually lost because of relying upon the statement under section 32. In spite of this, statement under 32 is made relevant. Why? That is because section 32 provides for 8 exceptions to the rule of hearsay evidence, which is inadmissible. But these exceptions, if the statements comes under these 8 exceptions, then it will be admissible under the Indian Evidence Act under section 32. Now, I put a question to myself: why would be such an exception to these statements when the rule itself says hearsay evidence is per se inadmissible? Because the party against whom it is put is in a very disadvantageous position or a situation. Now, there's another question, like why the statement has to be relied upon. The statement has to be relied upon in the following circumstances. The first and foremost reason is that the doctrine of necessity. Necessity is an important criteria to prove the case of a person. Second reason is that necessity arises due to non-availability of person though whom the case has to be proved. Third point is that necessity arises due to non-availability of same evidence for some other source or any other person to prove the case, or non-availability of some other source. Fourth consequences is that it provides for necessary safeguard. The Act itself and various guidelines or criminal procedure practice and rules provides for necessary safeguards. That is, the court will test the veracity of the statement. Before relying upon it, it will test the trustworthiness of the statement, and this statement is rebuttable. Ultimately, to rely on this statement, the court will ultimately satisfy itself. So these are the reasons why these statements are exempted from the rule of hearsay evidence. Now, I will read section 32. There is a section 32, cases in which statement of relevant fact by person who's dead or cannot be found, etc. is relevant. Statement, written or verbal, of relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be produced without an amount of delay or expenses, which under the circumstances of the case appears to the court unreasonable, are themselves relevant fact in the following circumstances. Following cases, that 8 exceptions. Now, I will say that the section states by saying that there has to be a statement. That statement can be written or verbal. Verbal includes signs, nods, gestures, all these things. All these comes under verbal. For example, when a person's throat has been slit by an accused, but he's still alive, if some passerby tries to help him and the injured victim wanted to make some statement, but unfortunately his vocal cord would have been cut because his throat is injured, so he can make a statement by signs or gestures, for certain questions put forth by the bystanders there. So this verbal word has been included in this section, which is very much important. Now, the statement has to be written or verbal of a relevant fact. What are those relevant facts? The relevant facts are themselves by relevant facts, which is stated there under the exceptions. So the statement written or verbal or relevant facts are themselves relevant facts if they are made by a person who are listed under the circumstances mentioned in this section. Now we would see what are the persons contemplated under the section 32. There are persons who's dead, persons who cannot be found, persons who has become incapable of giving evidence, and whose attendance cannot be procured without an amount of delay or expenses. So these four persons who gave the statement can be relied upon under the section 32. Now, coming to today's topic, that is relating to section 32 clause 1. I would read section 32 clause 1. When it relates to cause of death, when the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which related in his death, in cases in which the cause of that person's death comes into question. Such statements are relevant whether the person who made them was or was not at the time when they were made, under exception of death and whatever may be the nature of the proceedings in which the cause of his death comes to question. For a better understanding, I would dissect section 32.1. 32.1 is basically a dying declaration. So the dissection is that statement made by a person as to cause of his death. That statement should be related to cause of his death or reasons. And the second important thing is that as to any of the circumstances of the transaction which ultimately resulted in his death. Now, the fact in issue in the case is that death of the person. The relevant fact is that the statement made by the person regarding the cause of his death or regarding the circumstances and the transaction which resulted in his death. Now, what is a dying declaration? It is not defined anywhere in the Evidence Act. A statement made by a person when he was alive, subsequently dead, it is called dying declaration. Such statement becomes a relevant fact under section 32.1. It is simply known as dying declaration. A statement to be relevant under 32.1, there has to be certain proof. Here in this case, a death of the person must be proved. It is the basic foundation that a death of the person must be proved. So with this, I would just read section 136 of the Indian Evidence Act, which gives power to the court regarding the admissibility of the evidence. So this section 136 of the Evidence Act talks about giving exclusive power to a judge to decide the admissibility of the evidence. This section 136 gives sole power to the court. I would read the illustration A. It is proposed to prove a statement about a relevant fact by a person alleged to be dead, which statement is relevant under section 32. The fact that the person is dead must be proved by the person proposing to prove the statement before evidence is given of the statement. Now, with regard to the burden of proof, I will just again take you to section 104 of Evidence Act. The burden of proving a fact to be proved to make evidence admissible. The burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such evidence. Again, this can be explained by reading illustration A. A wishes to prove a dying declaration by B. A must prove B's death. So now it is clear that who should be whom the burden of proof should be there. The person who is seeking to prove the fact or statement, he has to prove the death. Now, section 136 and section 104 of Indian Evidence Act makes it very clear that who has to prove the death, and the burden of proof is casted upon the person who is relying on the statement. Dying declaration is a very unique evidence. It is the only evidence available from the deceased because he is no more. And in some of the cases, it would be the only evidence to talk about the occurrence. Dying declaration is given by the person who is on the verge of losing his life. He loses his motive to utter falsehood. This is one of his last chance to utter truth. The Honorable Supreme Court in 2006 9 SEC 240 has led and held that statement by a person who is on the verge of his death, such a statement is equated to that of a person who's administered a oath before the court. So through this judgment, we can see that the statement of a person who's on the verge of his death will be equated with the statement as if he has made it before a court under the oath. So that is the reason why so much weightage has been given and so much relevance it is drawn from the act. There are various types of dying declaration. First is the oral dying declaration and written dying declaration. Oral dying declaration is that a victim giving a statement to anybody orally. Written dying declaration is that before his death, he would have written a letter or any note, or he would have sent it to somebody, or he would have given it to anybody, or before the death, he would have given it to the hospital or relative doctors, anybody. And there is a judicial dying declaration and non-judicial dying declaration. Judicial dying declaration, nothing but a statement taken by a magistrate, or a victim gives a statement to a magistrate. It is called a judicial dying declaration. Non-judicial dying declaration is a statement given to any person other than judicial magistrate. Now, coming to the next point, what happens if a person who gave the statement survives? It cannot be treated as a statement under 32 because the main ingredient of section 32 is that person should be dead. In this case, if he survives, this ingredient is not at all fulfilled. So, after giving the statement, the person survives, this statement cannot be brought in as a relevancy of evidence under section 32. The statement cannot be used as a dying declaration. In India, it is not necessary that person making the statement should be actually dying. Section 32 states that person need not be under the fear of death. That ingredient is not there in section 32. It is a pre-requisite ingredient under English law, but that is not a pre-requisite under the Indian law. The fear of death is not very much necessary in 32 because 32(1) itself is very self-explanatory and gives a very clear statement about what has to be a statement and what statement can be admissible evidence that the statement should be relating to the cause of his death or circumstances leading to transaction of his death. Since the ingredient of fear of death is not there in Indian law as compared to English law, the term dying declaration referred can only be a declaration only because they say the fear of death is not there. So you can actually use it as a declaration only. It need not be called as a dying declaration. It applies to any death, in fact. There is a misconception among our friends that it's only used in criminal cases, but the section itself says it is applicable to civil cases also. Since it is called as a dying declaration, it is embedded in our mind that it is only related to criminal cases, which is a wrong understanding. Section 32(1) applies to any death, not confined to homicide. Death is the only fact in issue here. In whatever manner it is caused, it becomes a relevant fact. The moment it talks about the cause of death or the circumstance of sanction resulted in death. Death is not due to injuries inflicted by the accused, but due to any other intervening cause of, for example, if a death is caused to anybody, if a death is not caused due to injuries by the accused, but due to any other intervening cause, for example, if he dies of tetanus or if he dies of septicemia, then the statement given by the person will not fall within the meaning of dying declaration. Here, because before dying, he would have said that such and such person attacked me and because of that, the injuries have been sustained. But he did not die of injury, but he died of a septicemia. Then that statement cannot be treated as a dying declaration because that to come into the ingredients of section 32(1), it does not have the ingredients because the cause of death is different. Here, the cause of death is because of septicemia. For that reason, the cause of death is not mentioned, which is leading to death, must be directly related to the death. Due to subsequent incident or due to subsequent intervening incident, the person has died, then the status of dying declaration cannot be given. For example, if a person is attacked, very badly injured, admitted in the hospital, and at that time, he gives a statement to doctor about the weapon used to attack him, the persons who attacked him, the motive behind it, and after making the statement, after a while, the person survives and the case goes on. After sometimes this person met with an accident, or he falls down, or he suffers some other injury, or he died due to some other causes. Now, the statement which he made before dying, that is related to the way that the previous act, that statement cannot be treated as a dying declaration, because that statement talks about some other transaction but not to the related to the death. Here the reason for death is septicemia or some other death, some other reason. So what I would want to impress upon you is that the statement should be regarding the cause of death. So this has been enunciated in AOR 1964 Supreme Court 900. Now, section 32 reads and states that a statement has to be made only with regard to his death, not with regard to death of any other person, or as to circumstance as to his own death, and not with regard to somebody else's death. This is held in very famous judgment Ratan Gaunt is a state of Bihar in AOR 1959 Supreme Court 18, which states that statement must relate to his death and not to death of anybody else. Now, I would deal with the next part of section 32(1), the circumstance of the transaction which resulted in the death. This part actually widens the scope of inquiry and comprehends the chain of facts that might have commenced much before the person suffered any injury. The wordings are very much important here because it basically enlarges the scope of inquiry. The indication that you can rely on the chain of events till actually the incident takes place usually happens in dowry death. In dowry death, circumstances starts at the marriage, but it ends in the dowry death. There would have been a letter sent by the deceased wife to her father that can be treated as a statement given to a father and mother. That statement can be treated as a dying declaration. I'll give an example. A deceased A married husband B. Immediately after the marriage, she writes a letter complaining about her husband, that her husband is abusing her daily, harassing her, subjecting her to cruelty, and asking dowry throughout every day. And she might say that my life is getting miserable because of my husband. Subsequently, after a couple of days or a couple of months, the lady commits suicide. Then this piece of letter which she wrote to the father and mother can be treated as a dying declaration because it talks about the circumstances of the transaction which resulted in the death. Now, next is whether a letter can be treated as a dying declaration. Language used in 32(1), as just now told that, I told you that a letter can be treated as a dying declaration, is very clear as to any of the circumstances of transaction which resulted in the death in the cases in which the cause of person's death comes into question. The answer is letter can be used. In a very famous judgment by Privy Council in the year 1939, Pagala Narayana Swami versus Emperor, Privy Council AOR 1939, page number 47. Here, a victim receives a letter. The deceased receives a letter dated so 20th March. When he was asked to go to a place to collect money, but on 23rd March, his body was found in a mutilated condition. Here, the widow of the victim says that on the day her husband left the place, showed her a letter that he was going to such and such place to meet a such and such person, or the appellant's person in this case, to meet him. So in this case, he made a statement that I'm going for such a place. Now the question is whether this statement made by the deceased to his wife can be treated as a dying declaration. Statement made by the deceased is not relating to cause of his death, but it comes under second part of 32(1). I'm telling you again, the statement which he made in this case is not relating to the cause of his death, but it definitely falls under section 32(1), the second part of section 32(1), which relates to circumstances of the transaction which resulted in this death. So the Privy Council went on to the issue and decided the issue, the circumstance of transaction which resulted in the death. Privy Council stretched the term of the circumstances of transaction. I would like to just read you para 5 of this judgment. It has been suggested that it has been suggested that the statement must be made after the transaction has taken place, that the person making it must be at any rate near death, and that the circumstances can only include the acts done when and where the death was caused. Their lordships are of opinion that the natural meaning of the words used does not convey any of these limitations. The statements may be made before the cause of death has arisen, or before the deceased has any reason to anticipate being killed. The circumstances must be circumstances of the transaction. General exceptions indicating fear or suspicion whether of a particular individual or otherwise not directly related to occasion of the death will not be admissible. But statements made by the deceased that he was proceeding to the spot where he was in fact killed, or as to his reasons for so proceedings, or that he was going to meet a particular person, or that he had been invited by such a person to meet him, would each of them be circumstances of the transaction, would be so whether the person was unknown or was not the person accused. Such a statement might indeed be exculpatory of the person accused. The circumstances of transaction in a phrase, no doubt, that conveys some limitations. It is not as broad as an analogous use in circumstantial evidence, which includes evidence of all relevant facts. The statements made by the deceased on March 2021 that he was setting out to place where the accused lived on to meet a person, the wife of the accused who lived in the accused appears clearly to be a statement as to some of the circumstances of the transaction which resulted in the death. The statement was rightly admitted. As I told you, this statement made by the deceased to his wife that I'm going to meet a such and person comes under this second part of 32(1). The judgment expanded and stretched the term circumstance of the transaction which resulted in the death. How far can this be extended? There cannot be any straitjacket formula. It all depends upon the facts and circumstances of the case. Now, coming to the next topic, dying declaration, and in what proceedings it can be used. The nature of the proceedings can be anything. It can be civil, it can be criminal, but if there is a statement regarding the cause of death, then this provision of 32(1) will definitely apply. In English law, as I told you earlier, the cause of death must be called upon in question only if the case involving homicide. There, manslaughter, murder, here we have culpable homicide and murder. So section 32(1), it can be, the section 32(1), as I told you earlier, it clearly says it can be used in a civil case, provided the cause of death should come into question. In section 25 of the Hindu Succession Act, a murderer is disqualified from inheriting the property of the person murdered. So if you look at the illustration A of 32, I'll just read the section 32(1)'s illustration. The question is whether A was murdered by B. The question is whether A was killed by B under such circumstances that a suit would lie against B by A's widow. So this clearly says that the dying declaration can be used as an evidence in a civil proceedings. So we have to come out of that illusion that a dying declaration or a statement only applies to criminal cases, which is only peculiar to English law, which is not applicable here. So section clearly says that it can be used. Section 32(1) clearly makes a departure from the English law, and the imminence of death is immaterial with regard to 32(1), because 32(1) clearly gives an explanation. Now, my next point is that regarding the who may testify, as said in section 118 of the Indian Evidence Act. The person who gave the statement for all practical purposes must satisfy that he would have been a competent witness, that if he would have called to the court, he would be a competent witness under section 118. So 118, I'll just take you through 118, who may testify. All persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or from giving rational answers to those questions by tender years, extremely old age, disease, whether of body or mind, or any other cause of the same kind. So the person who is giving the declaration must satisfy that he is capable person to testify as in section 118 of the Indian Evidence Act. For example, a statement was given by an unsound, a person suffering from unsound mind. That statement would not be acceptable because if he brought before the court as a witness, he will be barred. there will be a bar under 118 so that he won't be giving in any evidence. But here in this case, the same parameter will be applicable to the statement of a person who is of unsound mind. So if a person is an unsound mind, something happens to him or after that. So, and if he gives a dying declaration to anybody, if a person is of unsound mind and something happens, some injury has been, or somebody tried to kill them, he is injured, and if he is giving a statement, that statement cannot be treated as a dying declaration because it will be hit by section 118. Now, coming to the next important point, that is a recording of the dying declaration. Basically, everybody is under the impression that a dying declaration has to be recorded by a magistrate. I tell you friends, dying declaration can be recorded or can be made to anybody. It can be made to a doctor, it can be made to a magistrate, it can be made to a private person, it can be made to a bystander, it can be made to a relative, it can be even made to a police officer. For this, there is a judgment of Supreme Court in 2012, 12 ACC 120, Surinder Kumar with the state of Punjab, where this the point which I have told has been elaborately discussed. Now, friends, it is one thing to state that it is admissible, but it is another thing, completely another thing to say that it is reliable. Now, all along I've been talking about only the admissibility. It can be, the dying declaration can be given to a police. You can't make a statement made to a police is inadmissible. It is admissible, but it is different from reliability. The probative value of the dying declaration can only be dealt at the later part. Now I'm only dealing with the admissibility. So if a person gives a statement to the police and thereafter he dies, the probative value will be treated later. The only point is that it is admissible. A statement given to a police officer is admissible because it comes under section 32(1), and there is an exception to section 162 that the 162 statement made to a police officer is inadmissible, but statement under 32(1) is admissible. So recording of dying declaration need not be reduced into writing at all. It all depends upon the situation of the particular case. That is why section 32 clearly says verbal. Dying declaration need not be reduced into writing. It all depends upon the situation of the particular case. Given for an example, if a person is lying in a pool of death, one passerby wants to help him, he goes there and he gives a statement. At that time, the person cannot go and running to search of a paper or pen to write. And by the time if he's going searching for it, he would have died already. So at that point of time, the person will be making a statement. So as I told you earlier, dying declaration need not be in writing. It can be oral or it can be given to any person. So therefore, a requirement in section 32(1) does not stop with writing. It stretches to verbal also, but it depends upon the facts and circumstances of the case. When it is recorded in writing, there are certain guidelines given in various judgments, guidelines given to magistrate when it is recorded in writing. As I told you earlier, if you remember, statement orally made to a magistrate will be written down. Here in this case, while magistrate is writing down the oral statement, there are a couple of guidelines given by the Honorable Supreme Court in various judgments. There is criminal rules of practice by various high courts. In fact, Madras High Court itself has a criminal rules of practice, which lays down various guidelines for magistrate to record the dying declaration. There are various basic rules which is to be followed by magistrate recording the statement. The first and foremost condition is that mental condition has to be satisfied. The magistrate has to satisfy himself about the mental condition of the person, mental condition of the victim who is making the statement. Second is that the magistrate has to take the statement of the doctor before taking the statement of the victim. Either he should have a doctor certificate regarding the mental condition of the person making the statement. The third important rule is that verbatim recording is very much important because it is a statement given by a person who is going to die. There cannot be any addition or subtraction with regard to that statement. So verbatim recording is very much essential and important, and not that the substance of what the person died said. So if he might have said something, but he would have written it in a different word. It can't be done. A magistrate can't do that. Verbatim recording. So to have a better weightage, it should be recorded in the very language spoken by the declarant. Translation also might create a problem. So if the statement is given in Tamil, then it should be recorded in Tamil. If he's giving a statement in English, it can be recorded in English. Sometimes there might be a problem in translation also. So language is very important. There is a vast difference between being conscious and being in a fit state of mind to make a statement. Being conscious is just a medical term. A doctor will come and say that he's conscious. but being in a fit legal state can be certified only by a magistrate. So some rational question has to be put to the victim, that how are you, who are you, what happened. Some basic questions has to be put to the victim, and after putting those questions to the victim, the victim should give a rational and proper answer. So the magistrate has to satisfy that the person is in fit state of condition, fit state of mind to make a statement. It is always good to have it in a question and answer format. In Surinder Singh, with the state of Punjab, that
Sir, we are muted. Please unmute you.
sorry. So there is no format prescribed for recording a dying declaration. Indeed, no such format can be prescribed. Therefore, it is not obligatory that the dying declaration should be recorded in a question answer form. There may be occasions when it is possible to do so, and others when it may not be possible to do so, either because of the prevailing situation or because of the pain and agony that the victim might be suffering at that point of time. Dear friends, more weightage will be given to the statement recorded by the magistrate. That's because for the following reason. Because a magistrate is an impartial judicial authority. Second point is that he has no intention or nothing to do with the case. Hence, his integrity and credibility cannot be challenged at all. And the statement given to a magistrate cannot be doubted. There is a guarantee that magistrate truly recorded the statement. So compared to the statement given to anybody, any relative or doctor or police, or to any non-judicial dying declaration, the dying declaration made to a magistrate has more weightage. Now, coming to the next little interesting question, whether an incomplete statement can be used as a dying declaration under this section 32(1). Supreme Court says if the statement is relating to the cause of death, the incomplete statement relating to the cause of death, then it can be used as a statement under section 32(1). This is enunciated in the AOR 1956 Supreme Court 168. Abdul Sattar is a state of Maharashtra. But in Privy Council, in Cyril Wagh versus King, 54 Calcutta WN 503, wherein their lordship were of the opinion that the dying declaration was inadmissible because on the face of it, it was incomplete and no one could tell what the deceased was about to add. Similarly, in Ramnath, which is a state of Madhya Pradesh, it was held that the extract, I'm just reading the extract, it was not safe to convict an accused person merely on the evidence of dying declaration without further corroboration because such a statement is not made on oath and it is not subject to cross-examination. And because the maker of it might be mentally and physically in a state of confusion and might well be drawing upon the imagination while he was making the dying declaration. Okay, now coming to the next thing. What happens when there is a multiple dying declaration? The person must have first given a statement to a doctor. Thereafter, you are given to a statement to a police or to a relative or to anybody in a very different order. If there is a multiple dying declaration, it will be based on the consistency. If the statement is consistent, and there may not be any problem at all, but problem arises only when there is inconsistency. The statement is improved or there is any omission with regard to the previous statement, then there is a problem. Generally, the first statement would be taken into account. But I'm telling you, friends, there is no hard and fast rule regarding to this. It will be depend upon the facts and circumstances of the case. Where there is a multiple dying declaration with inconsistency, the court has to look for some corroboration. When there is any suspicion over the dying declaration, then it is better to look for a corroboration. As stated in 2012, 7 SEC 569 in Sudhakar versus State of Madhya Pradesh. Now, my next question is that does dying declaration requires any corroboration in every case or all the cases? If the dying declaration inspires fullest confidence of the court, then there need not be any corroboration at all. The court should make sure that the dying declaration is not tutored. The person is in fit state of mind while making the statement. For that, the magistrate marking would have been there. The conditions are satisfied and the court is satisfied that dying declaration is completely reliable. The dying declaration can be the sole evidence to convict the accused. Corroboration is just a rule of prudence, friends. So if there is any suspicion or is inconsistency in the statement, then the judge can look for corroboration. The dying declaration is mostly used in the case of dowry death, where the wife is burned to death. Due to the burn injury, victim will be in the delirium, which means stage where the mind is not in their control and they will blabber anything. At that time, victim will be prompted by somebody and the victim might adapt to the prompted story or statement. Since the victim is not in control of the senses, therefore, that is why the mental state of the victim becomes very much important. It is scientifically proven that when the delirium is happening, the person may adopt the person who is tutoring him. Now, what happens when a policeman goes to the hospital and wherein the victim is admitted and he records the statement of the victim in the hospital? That statement comes under section 161. And thereafter, that will be treated as a complaint and FIR is registered. And thereafter, if the person dies, now what is the value of that statement made? Now, the question is that whether the FIR can be treated as a dying declaration. The statement made in 161 becomes an FIR. Now, the question is that whether the FIR can be treated as a dying declaration. Supreme Court says yes. In 1999, 2 SCC 126, Paras Yadav, which is state of Bihar, it says that FIR can be treated as a dying declaration. Then the 161 statement made by police during investigation. What is the value of the 161 statement made during the police station? For example, the person is murdered due to a completely different incident, but he gave 161 statement. In one of the cases where the prosecution wanted to bring that statement as a 160 as a dying declaration, the court said no, it cannot be relied upon because it does not talk about the transaction of death or reason for death. So the court said that statement cannot be used in this case, held in 2008 5 SCC 597, because it did not talk about the cause of death or circumstances of the death. Now, coming to the evidentiary value of the dying declaration. The evidentiary value depends upon completely on the facts and circumstances of each and every case, which is in the realm of appreciation of evidence. A person makes a declaration while he was in hospital and he did not die. Then what is the value of the statement? Supreme Court said that that statement can be treated as a formal statement under section 157 for corroboration. That statement can be treated as a contradiction under section 145 of the Indian Evidence Act, which has been held in section in a very famous judgment, Ranjit Singh versus State of MP in AOR 1983. 1983 Supreme Court 126. Now, I would like to end my lecture with a Latin maxim: Numo mariturus proximator mentria. A man will not meet his maker with a lie in his mouth. This is the basic concept for this dying declaration. Thank you, friends. I would ready to answer any questions if you have any.